We're getting close to the end of the chapters. I'm going to be finishing up warranties on this particular talk. Then we have 2 more chapters to do. Before I start, I have to give a shout out to my grandson who is still providing technical assistance, and he may be the only one watching these videos, so I got to make sure I put that in there. What I'm going to do in this one is very briefly go through the little bit that we have left in the chapter. I divided it into 2 parts because this chapter is so essentially important to what we are doing in this section. Tonight I'm going to just talk a little bit about what's left of the book. I'm going to show you and point out what I want you to look for in the examples that I have put on Canvas. Then I am going to go through one of the questions that's on your review sheet, which is due pretty shortly, so I hope you're kind of working on that, and give you a little bit of a few pointers as to what's going to be on the last test. Because this question that's on your review sheet, some form of that is going to be the question that's on the last test. So let's start off where we picked up last time, which was we had talked about the theories of product liability, and there were 5 of them. Breach of an express warranty, breach of an implied warranty, both of which require a sales contract and are under Article 2 of the Uniform Commercial Code. Then there is also negligence, an intentional tort, usually fraud, and strict tort liability. Those are not mutually exclusive causes of action, theories of liability. You could file a lawsuit and allege all of those or any 1 or 2 of them that you want to. It may be possible at the end you'd have to pick one, but they're not mutually exclusive. You don't have to pick one, stick with that, and that's it. All right, so let's start with that, leaving off from talking about implied warranties. So let's talk about, okay, what happens if you are alleging that there was a breach of the warranty of merchantability? Merchantability, if you recall, is an implied warranty that is given by a merchant seller, and it says that the goods that they are selling are fit for their normal use. The word that's used is merchantability. It's fitness for their normal use. If you are alleging a breach means something happened, that warranty was not right, then you have to prove a couple of things. You have to prove that there was a defect in the product, and you have to prove that that defect is what caused the harm, because you have to have suffered some kind of harm before you're going to have any claim for damages or anything else. You've got to do that. So you've got to show that there was a defect in the product and that that defect caused your harm. Now these kinds of defects could be different. It could be a manufacturer's defect, it could be a design defect. Think back around to some of the Takata airbags and things like that, what was wrong with them. It could be a failure to or inadequate instructions on how to use the product. Or it could be that there was inadequate warnings given against the dangers in this particular product. So any 4 of those things could constitute what you need to show that there was a breach of the warranty of merchantability. The product was defective, the defect caused the harm. All right, so I put some of these online, and let me just talk about a couple of them and point out what I would like you to look at. When we're talking about, and some of these are very simple products, they're products that you have around the house maybe, things that you might not think of, that there are warranties, and why all of this information is put on the packaging and the labeling that comes with the product. For example, this is a Swiffer Sweep-N Track, which I think is about $20. And on this, in big letters, there's warning. And then it lists out, and you can actually see these if you look at the picture that's on Canvas, it lists out all the ways that you are supposed to use this product. And it's important safety instructions, and it tells you to keep these instructions. For example, it says, warning, fully assemble cleaner before operating. Do not use outdoors or on wet surfaces. Do not allow to be used as a toy. Use only as it is described in this manufacturer's manual. Now, you might believe that this company is putting this on there because, you know, they're wonderful people and everything's just great, but it's also on there for a legal reason. They want to make sure that you have been given adequate instructions on how to use this product. And remember, this is a sweeper. We're not talking about something that's huge and got all kinds of parts. And yet this thing, when you look at it, is 4 pages long, done in several different languages, with pictures to make sure that you know how to use this product. Okay, there are more. This one. This is the pan that you have if you're cooking a turkey. Simple thing, right? Well, evidently a lot of people got hurt doing this because up in the corner, if you can read this, it says remove all juices from the pan with a baster before removing the pan from the oven. When removing from the oven, always support by the bottom of the pan. Do not lift by the sides alone. Failure to do this can cause injury. That is probably on there either because they've gotten sued at some point because there's handles on these things. And it makes it look like you could easily pick this up with a turkey in it and just lift it out of the oven. You can't. And somebody must have gotten hurt at some point. There are warnings on this now of how you use this product. I don't know how many people actually read that when they get the product, but it's on there. Your failure to read it is not a problem of the manufacturer or distributor or anything else of that particular product. They have given you the warning. Now, one that's come up lately a lot, and there were a lot of injuries, and this is why I'm sure that this is now, but if you can find, or again, I put this on canvas so you can see it, but the packaging for Tide Pods. And just as an aside here, but I marked on one of them with little blue dots, look on this front page how many items there are on here that are trademarked. This might be a good question for your test, to see if you can find this and find the answer to it. But there are a lot of trademarks on the front of this package. But for this chapter, what we're talking about are the instructions, the safety instructions and the usage instructions that are on the back. And there's a lot of them. They constitute like the whole back of this package is safety instructions. Keep out of the reach of children. That, of course, was the big problem with these, is that they're very attractive looking because they're multicolored and they look like they might be a plaything. They turned out to be very dangerous for children who would bite on them and then become severely burned by the thing that's inside them. But on the back of this, part of the reason that this is on here, there's a legal reason for this. And when we start talking about breach of these warranties, breach of the warranty of merchantability, they don't want anybody coming back and saying, we weren't adequately warned about this product, we weren't adequately told how to use this product. Okay, now also, let me tell you a lawsuit that happened about this, which it was inadequate warnings against the dangers in using the product. Now this lawsuit came, it's the maker of Louisville Slugger is who it was that got sued. And this was a case in Helena, Montana, which is not normally known as a really very liberal for their court systems in awarding money to plaintiffs. And they gave $850,000 to the family of this boy who was killed. What the family alleged was that the boy, was their son, was using an aluminum baseball bat, and that aluminum baseball bats are inherently dangerous because they cause the baseball to travel at a greater speed than a wooden bat. And they said their 18-year-old son did not have enough time to react to the ball being struck before it hit him in the head while he was pitching. And they awarded the $850,000 because they said that they had not been given adequate warning about the dangers of using this particular product. Now, did that amount get reduced? I imagine they settled it. I've never been able to find out what happened after this, if they appealed it. They couldn't find it anywhere. But juries, companies, take these lawsuits regarding liability for product liability for the breach of these warranties very seriously. And there are a number of lawsuits regarding that. Okay, so once they have these warranties out there, whether they have made them, because remember you don't have to make an express warranty, but implied warranties you do. So if you were the company, if you were the manufacturer, designer, one of the things you were going to want to do is to disclaim these warranties. Take them back. Say, no, didn't do that. Okay, so we do allow warranties to be disclaimed. You can have a seller and a buyer that agree that there will be no warranties. Okay, now, but there are certain restrictions on this in order for it to be a valid disclaimer of warranties. First of all, it's got to be conspicuous. Remember, I warned you, and I put a couple of these online too, and I'll talk about it in just a second. But anytime you're reading a contract, whether the contract is online, whether it's on paper, if you see something that's in bold print or in print that's bigger than the rest, make sure you read that, because that's very likely to be taking away something. And in this case, for disclaimer of warranties, these disclaimers are almost always, and these are ones on there, they're in much bigger and darker type than the rest of the paperwork that's coming with your product. It has to be conspicuous. It can't be hid in fine print. It can't be put in a paragraph that talks about some completely different topic. It has to be, we're taking back these warranties. This is a disclaimer that you are getting. Okay? It can't be unconscionable or against public policy, and I'll read you that in just a second. Many states have consumer protection rules. There are some Federal Trade Commission rules that say that in certain circumstances you can't take back warranties. Most of them are in consumer situations where you're not talking about a business, you're not talking about a merchant, but you're talking about a consumer. That they will find certain disclaimers, certain taking back these warranties to be either against public policy, to be unconscionable, or to be against a consumer protection statute of that particular state. Okay? Also, when you're disclaiming these warranties, sometimes they have to be using particular language. And there is a chart in the book that describes this very adequately. And that chart, if you look at it, is on page 468 in mine, but it is in this chapter. And it tells you exactly that there are some cases where if you are going to disclaim, take back a certain warranty, that you must use certain language. Okay? So for example, if you want to disclaim the warranty of merchantability, then you must use statutory language of as is or with all faults, and it's got to be conspicuous in the record. The record means whether it's a writing or whether it's online, whatever it is that's documenting this warranty that you're getting. It must be conspicuous, and it's got to use statutory language. It's got to tell you that we're not saying anything about this product. That's it, with all faults, as is. We are assuming no responsibility for this. But it tells you the exact words that you have to use. For example, if you are disclaiming, taking back the warranty of title. Remember, title is the one that says, yes, I own it and I have the right to sell it. Okay? You have to use the language, there is no warranty of title. If you were a consumer and you saw that and you didn't know what it meant, then it's definitely to your advantage to try to find out what that means before you get it. All right, so online you're going to see a couple of examples of disclaimers. Now these are, some of them are a little bit older than others, but the language is pretty similar in all of the ones that you get. So the ones I put online, for example, there's one for an HP inkjet cartridge. You wouldn't think that was such a big product that they had to take back a lot of warranties on that, but it does have one. And it starts off with, and you'll always see language that's something like this, to the extent allowed by local law, meaning that just because it says it in here does not necessarily mean that the state where you are allows it. So this is a disclaimer they're giving, unless a local law, state law, province law, if it's in Canada, takes it back. All right? It says the above warranties are exclusive. No other warranty, whether written or oral, is express or implied. And in this case, Hewlett-Packard specifically disclaims any implied warranties or condition of merchantability, fitness for a particular purpose, or satisfactory quality. To the extent allowed by law, the remedies in this warranty are your sole and exclusive remedies. In no event shall Hewlett-Packard be liable for incidental, direct, consequential, special, indirect, or lost profits from any breach of this warranties. Except that in countries, states, or provinces that don't allow that, then that limitation may not apply to you. There's always something in there saying, unless the law says this is wrong, okay? So they're taking back everything. And the second chapter from now, the last one that we do, covers remedies in sales contracts. And you'll hear those words again: incidental, direct, consequential, special, lost profits, those kinds of damages you will hear about again. They're saying we're not paying any of those. Generally, business to business, merchant to merchant, this will be okay. Once a consumer becomes involved, much less likely to be okay that they can take everything back. All right, and the one other one that I put online is one from Crocs. And this one I put online because I thought you might not have actually read one like this, and it's very similar to a lot when you do online shopping, that they may put this in there. And in this one, it's not talking about the product, the Crocs, you know, the shoes. That's not what they're talking about. This one, and I've marked in yellow what the most important part of this is, but it says we make no representations or warranties with respect to this website or its contents, which are provided for use as is, as available. We disclaim all warranties, express or implied, including without limitation, implied warranties of title, non-infringement, merchantability, quality, and fitness for a particular purpose. With respect to this website, we don't warrant that this website will be free of any harmful components, including viruses. We make no representations about the information being accessible via this website, and we're not guaranteeing you that it's accurate, complete, or current. Now, this was the only one that I could find that was easy enough to understand, talking about the website that they're using when you're doing online purchases. All right, so those are your theories of liability under the Uniform Commercial Code in this chapter. We've talked about the necessity of having a defect, and that there are basically 4 kinds of defects that you are going to be looking at, whether it's a manufacturer's defect, design defect, inadequate instructions on how to use the product, or inadequate warnings against whether or not the product is dangerous. Okay, but then we have these 3 other theories. So anytime we have a product that it's defective, that it has hurt somebody, you are not confined to just the Uniform Commercial Code theories of liability. If you want to use implied warranty either implied warranties or express warranties, you first must make sure that it is a sales contract. But then we can go on. You also could sue under negligence, you could sue for fraud, you could sue for strict tort liability. If you are talking about negligence, we have to go back to the very beginning of the chapters and remember that negligence is a duty of care. That duty of care was breached. That breach of the duty of care is the proximate cause of the harm that you have suffered. And so if you are going to allege negligence, you got to establish all those elements. If you want to sue under fraud, you have to establish all the elements of fraud. And since this, remember, this last test that you will be taking is over, for the essay part of it, the entire semester, you have to remember, and this is a good way to get into all the things we've talked about this semester, you have to remember that you need to know the elements of negligence and you need to know the elements of fraud. That it's a false statement of fact, knowingly made, that there was an intent there, that you relied on their statement, you did rely on their statement, and because of that you were damaged. So remember that these things all have elements that you have to show if you're going to sue someone. And we're getting a little bit towards the end of the semester, so these things become more and more important that you know about them when you're giving me your answers to these questions. Okay, and the last one, strict tort liability. In strict tort liability, it is just some areas where we've discussed before that we've simply said this is going to be a cost of doing business. And if they're doing business, causes harm, they're going to be liable. When we're talking about a product, we've got to show that the problem, the defect in the product was there when it left the control of the manufacturer or the distributor. Remember, that word control is really big in the law. That's another one of those words, intent, control. So it has to have been there when it left their control if you're going to try to hold them responsible. Okay? And remember again that these theories are cumulative. You could use all of them if you were answering the question. All right, let me talk then just briefly about one of the questions that's on your third review. And it's on the second page of the review. And this one talks about Angela going to a hair salon for her favorite hairstylist, Pat. She's been going there for 10 years. She decides to try a new hair coloring product recommended by Pat, only sold at this particular salon. The product's been on the market for 2 weeks. Okay? Pat uses the color, it looks great when she leaves the salon. That night, Angela decided the color was not what was advertised. She wants her money back. Now, the question to follow up on this one, what happens if she's injured by that hair product? Okay, well, if we're going to talk about the injury by the hair product, and we were talking about a lawsuit in the product liability, first we have to start. This, if you recall, is a mixed contract. There is an argument in here that this is a service contract, that she went there because Angela was her hairstylist. She's been going there for 10 years. She's worked there. That she, she'll take any product Angela says because Angela's just wonderful. And the product was just totally irrelevant. It was just incidental to the services. Or there's an argument that she used this product because that was the product she wanted and she was going there to get her hair colored, something that hasn't happened for quite some time, and that's what she wants to know. So we first have to decide what's the dominant element of this contract. If the dominant element is the sale of goods, then we might be able to use breach of the warranty of merchantability. We might be able to use one of the express or implied warranties that may have been given. It's possible that Angela here gave an express warranty about this product. We don't know. We could use those. If we decide that the dominant element of this contract is the service, then none of those are going to apply. Doesn't mean she can't sue. If she's been injured by this product, she still has negligence, she still has fraud, she still has strict tort liability. We still have other possible theories that we could use, but we can't use the remedies under Article 2. So the question that you're going to get on your last test, because it's going to be a long essay that you'll have to read and then you can answer some questions from it. One of the first things you are going to have to decide, and you are going to have to tell me in your answer, is this a sales contract? So you've got to make sure that you can answer that question. Okay? All right, the ones on your, this talk should be going on Monday, the 20th, online. I'm going to be starting to contact people individually shortly after that. When I contact you, have your answers to question 1 and question 2 and your exhibits in front of you when I talk to you, so that when I ask you questions, you can either show me your exhibits, we can figure out how you're going to send me a picture of your exhibits, and we'll talk about the case that you have in small claims. Okay, good night.